I hit start recording. This is like a big moment for us.
This is huge. This is week 2 of everything, or episode 2, I should say, of everything we know about the American heartland. And we're just talking about kind of what happened this week as a beginning point, and how this was the week I realized that Donald Trump was not going to put America first.
Can I ask a serious question?
Yeah.
Is there someone like typing on like a typewriter in the background?
Oh, you know what? That was me playing with something. Tom has kind bars at his office.
You have kind bars in your office?
Well, they're knockoff kind bars.
They're Kirkland brand, but still. Like, this is pretty amazing.
They're not kind bars.
They're like Kirkland brand kind bars. They're basically kind bars, AJ.
So when Ruchit said that they were kind bars, what he meant is that there are not kind bars.
They're basically kind bars. They're basically like white labeled kind bars.
They're generic kind bars.
Yeah. I mean, this is a scrappy plaintiff's lawyer's firm. You know what I mean? So if this was like, you know, they're kind of trying to dedicate their resources to the clients and not to the kind bars. Hence the Kirkland brand.
Kind bars are expensive.
They really are.
So, let me get this straight. So I'm like a military widow. Like, my husband died on the operating table in the VA hospital. The doctor left his wristwatch inside of my husband's stomach. And I need justice. I need access to the courts. And I come to Tom's office.
Yeah.
And I'm bawling my eyes out. I'm inconsolable.
Tom offers you
a Kirkland off-brand kind bar.
Yes.
And justice.
And justice.
You know?
It's either that or just have the kind bar. And since justice isn't something you can buy,
I feel like I would prefer to have justice served next to a name brand cereal bar.
They have a Keurig machine here, but not an espresso machine.
So you hate the planet and your clients' palates?
Well, I tend to use the non-Keurig machine, but, you know, whatever's faster, I guess.
Tom is pretty transactional as it relates to this.
I roasted my first batch of roasting my own coffee a couple days ago.
Did you really?
Yeah.
Why didn't you tell us about this?
I was saving it for this moment.
So what is your, well, I mean, should we talk about that? Should we jump right into what happened with the Ninth Circuit this week?
Yeah.
Maybe we should follow up from last week's episode.
Okay, let's do that.
All right, folks, we're going to call this segment Everything We Know About the Previous Episode that we did.
Yes.
Okay.
And the question is, you know, the Democrats were pretty ineffective at preventing Sessions or DeVos. What makes you think they'd be effective or at filibustering Gorsuch?
I don't think they would be effective at filibustering Gorsuch.
Okay, so what's the point of filibustering Gorsuch?
I think they should do it anyway. So, I mean, first of all, they have enough votes to filibuster Gorsuch, right? Like, they actually have more than 40 Democrats in the Senate. So, if they, on a party line vote, Gorsuch would not be confirmed under the present rules. So it would force the Republicans to either amend the rules, which may or may not work. They may or may not find the members in their caucus who want to do that. Or it would force some Democrats to have to switch sides in order for Gorsuch to be confirmed. But in either case, it's still more effective than just letting him be confirmed and not doing anything at all.
I don't know. If some Democrats defect, you know, in order to get to 60, that's a pretty risky game for them.
Well, okay, so let's give some background on this. The way the Senate rules work are there's a thing called a filibuster. In order to what a filibuster does is it prevents the Senate from actually voting on whatever measure is before it. In this case, it would be the nomination to the Supreme Court. If you want to end a filibuster, you can move for cloture. On a cloture vote, you need 60 votes. What the Democrats did in, I think this was in like 2013 when they were in control of the Senate, is they decided to end 60 vote filibusters for most cabinet appointments, and most presidential appointments. The one exception is that votes on the Supreme Court still require 60 vote cloture. President Trump has urged Senate Majority Leader Mitch McConnell to go nuclear, that is to end the 60 vote filibuster. for Supreme Court nominees, and I kind of think that if Republicans are already inclined to do it, the Democrats should make them go ahead and do it.
So I have a different strategy that I think they should pursue. I think they should basically goad Gorsuch into criticizing Trump. So you saw Richard Blumenthal kind of do that this week, right? I don't know if he actually goaded him into it or not, but Gorsuch certainly said, now it was a mild criticism as far as criticisms are concerned, but still it was like he was disheartened by the comments that President Trump had made earlier this week, criticizing the judiciary, criticizing the judge that was the judge and the judges that were ruling on these cases related to the travel ban. And so I think what they should do, which would be comical as hell, is if they can figure out a way through the hearing process or whatever else to get Gorsuch to say so many negative things about Trump that Trump withdraws his nomination. That would be hilarious.
I don't think Trump would ever withdraw his nomination. I think there are enough people in the White House that would stop him from doing that.
I don't know, but
Trump would withdraw that nomination.
Well, I mean, maybe Trump would withdraw the nomination. I guess the reason I think that he would is because he's so petty and like little, right? So I think like all you would need is for it to be a Saturday, right? Like as long as like Jared Kushner's not around to tell him otherwise, I think he'd do it.
Well,
you got to schedule these hearings strategically on a Friday. So kind of after the Shabbat, so that Kushner can't be there to be a voice of reason.
Along this vein, I read a news report that Rex Tillerson, Secretary of State Rex Tillerson, had wanted as his deputy at the Department of State.
Yes,
had wanted Elliot Abrams, and that Trump met with him and was all set to hire him and nominate him for the State Department. And then Trump read a news report explaining how critical Abrams had been of Trump during the election, and then he decided he didn't want to hire Abrams.
Yeah, that's exactly right. I think that's the exact tact.
So it's not quite the withdrawal of a nomination, but there is precedent for Trump deciding not to hire someone
once he learns that they have said bad things about him.
Yeah, but it's a far leap to say that he will not hire someone that he hasn't committed to versus withdrawing a nomination that's before the Senate.
Or he could just tomahawk it, right? He could like tomahawk the nomination just by somehow being Trumpian. You know what I mean? He could like say he's not going to withdraw the nomination, but he could just like hit on Judge Gorsuch like right and left, And I think this isn't as kind of silly and crazy as it sounds. I think if this was any other president than President Trump, it would be like very kind of naive to think that this could work. But I think if they can I think that's their strategy, to be perfectly honest. I don't think they should test the filibuster, and I don't think they should risk defections. I think that's the bigger issue, is I don't think there's going to be enough senators on the Democratic side. I think there's enough that are up for re-election. I think they are going to defect.
They would need 8 defections. Like, do you think you could name 8 who would defect?
Yeah, I think Blumenthal would defect. I think Manchin, McCaskill. Then how about are there any of the Ohio ones that are up?
The junior senator from Ohio is a Republican. The senior senator from Ohio is Sherrod Brown, who is what basically Bernie Sanders' closest compatriot in the Senate.
I don't know. I guess I can't name 8 off the top of my head, so good for your point. But I think that I do think that like they would get, because the other thing is that like the more people or the more that like Gorsuch has this like really nice fine line he could walk. He could criticize Trump just enough to make people think that he is a independent voice and is an independent-minded jurist. That's, I think, his game, Although I think for him, there's no loss. I think he probably gets confirmed. It's just a matter of how much damage occurs to him or to the institution of the Senate along the way.
Tom, you want the last word?
No.
You want to talk about everything we know about the Ninth Circuit?
Well, I can give a brief rundown of the opinion if you guys
do it, Tom.
So first, where is the Ninth Circuit?
Yes, that's a good question.
So the Ninth Circuit is a appellate court that governs or is the court of intermediate appeal for various states mostly on the West Coast. And this case arises out of Washington. And basically what happened is, Trump issued that executive order, and there are three things that the executive order does that the state of Washington and the state of Minnesota are challenging. First is a 90-day ban on any individuals from one of 7 countries: Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen.
And Tom, quickly, how many citizens of those countries have ever committed a terrorist attack in the United States?
I think that the total is a big zero.
Yeah. So Trump issues an order targeting citizens of countries that are majority Muslim on the grounds that they could be terrorists, when in the historical record, since September 11th at least, if not further back, there have been a grand total of 0 terrorist attacks killed by people who are citizens of those countries.
Yeah. So the second thing that the executive order does that's being challenged is there's a 120-day ban on all refugee admission into the United States. And the third is there's an indefinite ban on all Syrian refugees into the United States. And so the state of Washington, later joined by the state of Minnesota, say, look, we have professors and students and all sorts of folks that for academic reasons and other reasons need to visit these countries and need to come back. So this executive order is really interfering with our ability to conduct business, and therefore the court should enjoin or prevent the executive order from going into effect while the court decides whether or not it's a legal executive order. And so the district court below found, that the president should not enforce this executive order while the courts decide, and that was a nationwide basically ban on the ban is what I'd like to think of it.
Tom, who is this so-called judge?
I don't think the judge himself is not important, but when the judge talks, the judge is talking for the court, and it's the court that's actually issuing the order.
Who does he think he is that he has this power to tell the president of the United States what he can and cannot do? And maybe I'm being a little glib here, but it might be helpful just for a second.
Well, that's the first issue that the court deals with, is where are they getting the power and whether or not they have the power. Because what the first roadblock, or the first substantive roadblock the Trump administration argued in front of the Ninth Circuit was, look, not only do you have this power, but when the president acts on these immigration-related issues, the court has absolutely no power to say one way or the other, even to touch. These issues are unreviewable by the courts. And the Ninth Circuit pretty much just effectively dispatched that argument by a long list of string cites, just citations where the court has done this, and the court is basically saying, no, we do have the power. And this comes back to this idea that, the president does have certain powers in the realm of foreign policy and the realm of immigration, and the courts do give great deference to that power, but that power is not unlimited, and that power via the Constitution is reviewable. When the president acts, for example, pursuant to a mandate of Congress, that's where the president's power is at its greatest. When the president is acting without a mandate of Congress, the president's power is still strong, but is not as strong as when they act with Congress. When the president acts against Congress, that's when its power is the lowest. So in this case, we're in that middle zone where Congress hasn't issued any sort of statute authorizing the president to do this. In fact, there's good argument that there's statutory authority preventing the president from doing this. So that's what the court is dealing with in terms of the reviewability and the president's power to act in this case. And the court draws its power from the Constitution. This is just a pure constitutional issue.
It just seems like the lawyering for the government was so bad, like the actual quality of legal argument made by the government was bad, in my opinion. And an example is this idea that the judiciary cannot review the executive action in this area. no matter how bad the executive action is, the judiciary is just plain unreviewable. Like, I don't know what compelled them to make this stupid of an argument.
Yeah, it was especially easily dispatched too. So it's not, the court cited numerous specific instances when the judiciary has done this and can do this. So it's I don't know why they decided to make that argument, other than perhaps maybe setting it up for the Supreme Court to hopefully decide in Trump's favor in their mind.
It's also possible that the Ninth Circuit opinion gives short shrift to the briefs that were filed. So you can keep a few things in mind, right? In the middle of the time that the government would have had to respond to any of the briefing in this case, the Assistant Attorney General Yates was fired by Trump, and a new person was brought in to lead the Justice Department. And then, but Trump actually tweeted that he was quoting a blog called Lawfare, and there's a section of the immigration statute, and what the statute says is that the president has the power to deny entry to any class or classes of people if the president decides that entry of those aliens into the United States would be detrimental to the interests of the United States. So it sounds like there actually is a broad delegation of congressional authority to the president, and it doesn't seem as though Congress has made any room for anyone else to review those decisions of the president. So the legal precedent there is that the Supreme Court has said that you can't switch the Constitution on or off at will. So Congress can't turn on or off the reviewability of some action. But that precedent hasn't been applied to the immigration sphere. So I think it makes perfect sense to at least try, right? I mean, you can present arguments in the alternative. It's not like this was the government's only argument.
Yeah. Yeah. Well, and with regard to whether the president can do it or not, I don't think that's, at least from the court's perspective, I don't think that was the issue, right? Like, the president can prevent people from coming into the United States, based on a whole series of reasons. The issue is whether, the end issue is going to be whether when the president does this, has the president provided the people he's denied entry to, or he's affected in one way or the other, the appropriate procedural and substantive process that's required under the Constitution. And just for, I guess, background, the Constitution says before your rights can be impinged, the government has an obligation to provide you certain due process, and what that process is depends a lot on the circumstances and the rights that are being taken away. And so the issue before the Ninth Circuit and the court below is, well, we're going to prevent the president from doing this while we decide it. So the question is there a likelihood that due processes of these individuals are being violated? The technical term is likelihood of success on the merits. And in this context, at the Ninth Circuit, the government has the burden to show that no, there is no likelihood of success, and the court basically said they didn't meet that burden.
So the thing that struck me as on the likelihood of success angle is the Ninth Circuit says explicitly that they're going to look at Trump's campaign statements, that they're relevant to the analysis of whether the ban has some sort of animus targeted at certain religions. They refer specifically to the fact that the two main petitioning states, Minnesota and Washington, have offered evidence of numerous statements by the president about his intent to implement a, quote, Muslim ban. Mm-hmm. And it is the court says that it is well established that evidence of purpose beyond the face of the challenge law may be considered in evaluating Establishment Clause and Equal Protection Clause claims.
AJ, sorry to interrupt you, but isn't that like, this is just another way of saying that Sally Yates, the assistant or the acting attorney general, is right, which is to say that's where she based her authority on as well, or not her authority, but her interpretation of the executive order was on some of these statements of intent. At least that's sort of what it felt like,
Well, I think that's everyone's reaction, right?
And the other thing,
it just seems so obvious.
The other thing that I would add is that, this goes back to your point earlier, Ruchit, that the government didn't really put its best foot forward in defending this law, or not this law, but this executive order. One, in the sense that, they made arguments that are pretty strong losers. And two, in the sense that you could imagine a world in which, let's say you have a presidential candidate who didn't make the type of statements or who didn't run the campaign that Trump did, and then decided to enact a very similar executive order, right? In most cases where the law is dealing with these types of issues, there's never clear evidence of intent. There's never a smoking gun that shows us what the defendant, or in this case, the United States, what their intent was when they acted in one way or the other. But in this case, Trump basically handed them evidence of intent by making these statements, and so that hampered his team's, his administration's ability to defend this executive order in court.
Yeah, and I think that's just a problem they're going to keep on having, which is Trump is going to keep saying what his intentions are, and so you could call that straight talk, or you could call that kind of stupid, right? Because and honestly, it's a good thing, right, for us, I guess, as people that disagree with him on this issue, that he's so transparent about what his intentions were. So it prevents his lawyers from going in with a straight face, at least effectively going in with a straight face, and saying, well, he didn't mean Muslim ban. And as a result, all they're left with is, you just can't review this, because the moment that you do review it, it's hard to see how it stands. It's hard to see how it stands on the facts, which is how many people have actually, how many of these immigrants have actually come into the country and committed a terrorist attack. Well, the answer there is 0. And so the necessity of the executive order kind of falls flat on its face. And even if you don't think that the court should be thinking about whether this executive order is necessary or not, certainly its discriminatory intent becomes extremely clear as well.
Eric Posner, who is a professor at the University of Chicago,
is he related to Richard Posner? Do we know?
He's his son.
Son of Richard Posner. So these are, for the folks listening, these are great lawyers here. So it's like Antonin Scalia's son. Isn't Scalia's son a lawyer as well?
He's got like 12 sons.
Oh, he does. He's Catholic. That's right.
Yeah. He's bequeathed to each of them a portion of Israel.
But Eric Posner said, AJ.
Eric Posner said Trump's tweets will haunt him for all national security actions going forward, interfering even with legitimate government action. I mean, what do you all think about the idea that Trump's campaign was so shambolic that even things that he tries to do that may actually be good or smart are going to be hampered by his past campaign rhetoric?
I didn't see him propose a lot of good or smart things. But actually, no, you know what, let me take that back. There is one good or smart thing that I saw him pose, but I don't know how his tweets will interfere with legitimate government action on this one. But that's drug price negotiations, right? So one of the things, it's funny, I talk to so many people that dislike Trump in every way, but they're like, man, he is so right. Medicare should negotiate drug prices with the drug companies. Drug prices have gone too high. These companies are making too much money. We need to negotiate that.
Pause for a second. I thought Medicare did negotiate drug prices and all sorts of prices. And I thought that was part of what made Medicare so successful, is because it had a lot of power, basically, because it had a lot of insurance across the board. It was able to negotiate both reimbursements and drug prices.
I think they can negotiate on reimbursements. I do not think they're able to negotiate on drug prices.
What prevents them from negotiating?
A law passed by Congress in 2003.
Why did Congress pass that law?
To protect drug companies.
A handout to the industry.
That was part of the deal. In 2003, George W. Bush wanted to expand Medicare and to basically cover prescription drugs as well, because I guess at that point Medicare did not cover prescription drugs. And what the drug company said is like, listen, we would love to have that extra revenue, but don't you dare put any limits on it by negotiating with us. And so
Is it called Medicare Part D?
Yeah, Tom, they're not allowed to. they are not. Yeah. So I mean, that's like just manifestly terrible public policy, right? And the only argument that one can make against it, which I think some people like Paul Ryan made, was if the government is able to negotiate, they have so much power that they can basically drive these companies out of business and prevent them from ever investing in R&D and blah, blah, blah. But as a practical matter, I don't think that was ever possible. But I mean, theoretically.
Wouldn't the same argument apply to the insurance companies that that Medicare has negotiated reimbursements on? Or not insurance companies, but providers, rather.
So I think there's actually, I'm not super familiar with this area, but I think there's actually an independent commission that decides these prices. And the commission is made up of the doctors that provide these services. So
is that the death panel?
No. The death panels are different. These are the life panels, I guess. But yeah, so these commissions, there's a good article on this. Maybe we can make this a topic, actually, guys, because there's a few good articles on sort of drug pricing and how Medicare, or not just drug pricing, but like procedure pricing and how Medicare decides what to pay. But it's a pretty opaque box, and it is controlled by the industry because it's some third party that's composed of members that are appointed by, so on hip surgeries, it's like a bunch of hip surgeons that are making the decision, or it's a committee of hip surgeons deciding what is the appropriate reimbursement rate.
So what do you think about the Ninth Circuit? Should we still have a Ninth Circuit? Has it outlived its usefulness?
Yeah, I just don't think the Supreme Court can handle all these cases. Also, I think the Ninth Circuit, if nothing else in terms of proving its usefulness, has cited arguments by the Fifth Circuit. And so that's the other big issue of this case. I think there's probably, so Tom talked about reviewability. There's the underlying constitutional issue of whether the executive order is unconstitutional. And then the last issue, or which was really one of the first issues, was standing. And so standing is actually where the Fifth Circuit gets involved a little bit. Tom, do you want to talk about standing?
Honestly, I didn't think the standing issue was that big of an issue, at least for the Ninth Circuit opinion, because, just for background, the government is arguing that, look, the state of Washington and the state of Minnesota have no standing to challenge the executive order. And standing is this idea that, look, before you go and sue someone in court, you should have a personal stake in that lawsuit. It shouldn't be, you shouldn't just be going into court and asking the court to issue rulings on things that don't personally affect you, right? And the government's basically arguing, well, look, Washington and Minnesota aren't personally affected by the executive order. And Washington and Minnesota's response is, no, look, we do a whole host of things that this executive order affects. And the primary examples they gave is we have higher education institutions that, for example, bring professors from abroad to teach at our courses and send our academics abroad to research and study. And, that's going to cause problems. The executive order is going to cause problems in terms of their travel, their fear of getting back, their ability to come back if they do go abroad. And so these are all things that give us, as the state of Washington, a personal stake in this lawsuit. And the court fairly easily agreed with them. I mean, the thing you got to remember about standing is that it's a pretty low burden. I mean, it is. You just have to have some interest in the lawsuit, some personal connection to that lawsuit that allows you to bring that lawsuit.
I guess I disagree with you. I think the standing has been used by conservative courts to deny people right to the courthouse, right? And the most classic example of that is public interest groups. So when public interest groups bring a lawsuit on behalf of their members, the courts are somewhat exacting, I think, on standing related issues. And I think actually the idea of states bringing a lawsuit saying that they have suffered irreparable harm or have suffered harm is a pretty novel one. And I think what's funny to me, at least, is that the Ninth Circuit, as for reliance on the idea that a state can bring this type of lawsuit, actually cites the Fifth Circuit. So for people that don't know, the Fifth Circuit is the federal court of appeals that is one of the most conservative circuits in the country. So people think of the Ninth Circuit as one of the most liberal because it contains a state like California, and people think of the Fifth Circuit as one of the most conservative because it contains a state like Texas. And so the Obama administration in 2012 used this exact same standing argument to make the point that the state of Texas could not sue the Obama administration based on its decisions regarding immigration and deciding to defer action. And the Fifth Circuit, interestingly enough, sided with the state and said, no, the courthouse door is open to the state. And the Ninth Circuit here, very cleverly, I think, is citing the Fifth Circuit.
Rich, do you know how flimsy Texas's argument about standing was in that case?
No, I don't.
If you listen to the oral arguments when that case was heard at the Supreme Court, Texas alleges that they are affected because people who have these temporary release from deportation have the ability to obtain driver's licenses in Texas, and that Texas will incur costs in providing driver's licenses to these people.
Yeah, I mean, and I think you look at that and, you know, it doesn't seem like a far stretch from that to say, well, the universities of a state will face damages, and as a result, the state will face damage, you know?
Washington alleged that they have a scholar who was en route to work for one of their universities and was stopped in transit, right? So their university has suffered immediate and concrete harm.
Yeah, I think Washington's, the state's arguments in this case are a little bit stronger for that very reason. You know, one of the things that the universities do as a matter of course is bring scholars from all over the world to teach at their schools and send their scholars to all over the world to research and teach. And so an executive order that prevents their professors from traveling is definitely something that is going to affect their day-to-day business. I mean, I didn't think that was a controversial point, but I mean, maybe I'm wrong.
I felt like it was. That was something that was raised, I think, at the district court level. And I mean, this is just me making a prediction here, and I hope I'm wrong. But I think if this thing gets thrown out, it's going to get thrown out either on whether or not the judicial branch can review this type of executive order, or it's going to get thrown out on standing. And I'm personally afraid that it gets thrown out on standing, because I think that one of the big tools that states are going to have over the course of the next several years with the Trump administration is going to be the ability to sue and access the court system on all kinds of like inane and stupid things that Trump decides to do.
I've got another ridiculous standing argument that the Supreme Court has entertained recently, Richard. Do you remember the Abigail Fisher against the University of Texas case?
I do.
So this is a case where there's a woman, her name is Abigail Fisher. She applied for admission to the University of Texas. She was not accepted. She said that because she was not a racial or ethnic minority, that she experienced some sort of dispreference in her application, and that was a violation of the Equal Protection Clause because she was discriminated against on the basis of her race. By the time the case had made its way up to the Supreme Court, she had since graduated from LSU, and she was doing whatever it was she was doing, but she had no interest in attending the University of Texas at that point. And the Supreme Court asked her attorney, one of the justices, I think it might have been Sotomayor, asked Abigail Fisher's attorney, what is it that you want in this case? What is the harm that you need addressed that would give you standing to participate in this proceeding at this point? Isn't this moot? She's already been sent to another university. And what her attorney said was, we would like Abigail's application fee refunded.
Yeah, but hold on there. There's a very special exception to the general standing rules for situations like that. It's you know, the capable of repeating exception. It's where, you know, because of the short nature of the thing that you want, the harm that you want fixed, like the short time frame that the harm occurs, and the fact that it takes forever for courts to do anything. This idea that, well, look, even though your issue now is moot, this is an issue that's going to come up over and over again. And if we dismissed every case that this issue came up as moot because it happened so quickly, and then you go to another school and you no longer have the harm, judges would never get an opportunity to review that, and harm would be left the justice wouldn't be served. So I think that's, I mean, to me, that's also an easy case of standing.
That is not the theory that Abigail Fisher pursued. I don't see it addressed one way or the other in the opinion that I'm scanning through it right now. But the point I'm getting at is that
the Washington v. Trump opinion, the Ninth Circuit opinion.
No, I'm talking about the Fisher v. Texas opinion. I don't see the capable of repetition yet evading review standard addressed one way or the other in this. And so the point I'm getting at is that it's sort of there have been so many incredibly flimsy standing arguments recently. It sort of would seem difficult for me to imagine the court making an about face on its expansive view of standing that it's had over the last, say, 4 or 5 years.
Yeah, good point.
Although it's actually not that difficult if you think of the court as a more partisan institution.
Yeah. So one of the things that I wanted, and this is, maybe I'm just harping on this too much, but I feel like this is something I'm scared of, which is that Trump will eventually hire people that know what they're doing, and they will draft an executive order that complies with the law, right? That is just a little less absurdly unconstitutional, And I mean, he sort of said that. I think that they're thinking about redrafting the executive order, but it is pretty troubling. Yeah, please.
Yeah, well, I have a hard time seeing exactly how they're going to do that, because remember, this Ninth Circuit opinion isn't an order on what the law is,
right,
or what what the government could or could not do to make get around the hurdles that are in place. The issue in this court is whether, look, are we going to prevent the government from enforcing this executive order? And the standard by which the court decides whether we're going to let the government enforce this executive order is this idea of it's a 4-part test. First, what's the likelihood that the state of Washington is going to succeed on the merits? And in that sense, they do go into the substantive analysis of whether there's a due process violation and whether there's religious discrimination. But it's a very, very superficial glance over these two issues. It's not a very in-depth analysis. It's simply, look, it seems like there's definitely enough here for it to go forward. It doesn't seem like the government has hit the ball out of the park here on their case. So we're going to move forward on that. The other issues is, look, is there going to be irreparable injury to the government if we do this? And 3 is it going to harm the state if we don't do this? And then third, what's the public interest in preventing the government or not preventing the government from enforcing this executive order? So yes, they could more narrowly tailor the executive order to maybe give a hearing and due process and that sort of thing to these individuals they want to deny. But honestly, I don't think Trump wants to do that. I don't think Trump wants to create more bureaucracy, because remember, you can't kick them out while they're waiting for their hearing and such, right? Like, yeah. You can't just say, well, you're not allowed in. You have to do something with these people, and that includes the refugees and these other individuals while they're waiting for their hearing, their hearing on the merits of whether they should be or should not be let in.
I'm kind of afraid to even suggest this, but I'm kind of thinking what would I do if I was a competent version of Trump and I wanted to achieve this goal that he wants to achieve, which is to basically have an effective Muslim ban, right? At least from these 7 countries, at least for now, And I mean, I'm kind of I don't know, I'm hesitant to even say it, but I mean, should I say it? Should I do it? I don't know. Should I give Trump advice here?
Trump is probably not listening to this podcast, so
dude,
you can say it.
You never know, though. Trump is very, very interested in what the media has to say.
Yeah, and we are the media now, And, I mean, we could be part of his routine, the way Morning Joe is. We could be right before Morning Joe,
I don't think I wake up that early.
No, for him, for his podcast listening, you know what I mean? I'm definitely not waking up before Morning Joe. I'm definitely not waking up. I mean, isn't Morning Joe at 6 in the morning? That's early, man. So here's what I think he would do if he was competent, which he's not. I think he would basically put a new layer of vetting that occurs at the embassy level. And he would basically just let the people that have already been approved in, because that's actually what this is about, right? This is about people that have already been approved. It's not as if, like, you're in Somalia and you're like, I really want to go to the United States today. Let me get on a plane. That's not how it works. That's not how it worked before Trump's executive order, and that's not how it'll work after his executive order. So maybe he would just require like additional meetings, additional vetting, he could basically just make the process so terribly hard that no one from these countries could come in. The other thing I suppose he could do, which again, he wants to favor Christians, so I don't know if he could do that.
Before you go to the second, I'll just say you'd be surprised at what immigrants are willing and able to do.
That's true.
To get into this country as an immigrant myself.
That's true. Me too. Yeah, that's true. I don't know everything that my parents had to do, but I do know that as the years go by, it has gotten tougher and tougher for people to get in, and it has required more and more interviews and things like that. And that's just from a place like India, right?
Have I ever told you all my green card story?
I don't think you have. So we have actually, this is something important for the listeners to understand. We have 3 people on this podcast. All 3 of us immigrated to this country.
So I was living in the U.S. for a while. I moved here when I was fairly young.
Illegally, I presume.
And, a little of both.
More legally than Melania.
AJ did not have creative employment structures. Let's put it that way.
We all went to the green card office to apply for green cards, and they told us, if you don't hear from us in 6 months, let us know. You probably ought to hear from us in 6 months. The 6 months go by, and we call them back. We said, we never heard from you. And they said, yeah, someone lost it. Why don't you all come back? And so we go back, and they say, okay, this time we're going to try to rush it through. And to their credit, the second time was the charm. They actually gave me a green card. A few years later, I got like a job bussing tables when I was in high school. And I went to go get a Social Security number from the Social Security Administration so I could work. I went, and they said, you should hear from us in a week. And I said, great. And then about a week later, I got a letter in the mail, and it said, you should hear from us in about a month. And a month went by, and I called them, and they said, somebody lost it. Come on back to the office. So I came on back to the office. And, second time was a charm. They actually gave me a Social Security card that time. And that's my story. And that's the story for someone who sort of didn't... I don't consider that to be particularly many difficulties. It's not like I was like fleeing the ravages of civil war.
You were coming from Canada, buddy.
I just wanted to bust the tables at the Italian restaurant.
You wanted to take an American job, basically.
You
wanted to do a job that no American would do.
Yeah. You know what? I did that job. I did that job for like 6 months, and then I bought a guitar amp.
Good job.
Guys, it has been lovely talking about this. What should we do?
Well, I just want to add one more point about one more thing about the Ninth Circuit ruling, and that's they're deciding whether or not the states have a likelihood of success, and the states bringing basically 2 claims. One is due process, whether these folks got the process, a notice and hearing, before they were denied their rights, and the second is religious discrimination. On the first issue of due process, the Washington's argument, about whether or not these folks got notice and hearing, the government's response to that argument is, well, look, these are immigrants. They have no rights. And, that's pretty crazy. Maybe crazy is too strong of a word, but it's certainly an extreme position for the government to take. And the court did bat that down pretty easily, because the Fifth Amendment applies to all people, whether they're lawfully present or unlawfully present, whatever their immigration status is. The requirement of notice, the requirement of giving them due process before you deny them certain rights, in the immigration context is certainly there. And I don't know. Did you guys pick pick up on that, or think that it was extreme or not for the government to be arguing these individuals have no rights at all?
Well, I think that's a common trope among certain circles, that there's a widespread misbelief that constitutional protections only apply to people who are citizens of the United States.
Yeah, but these are lawyers.
And,
but these are not, this is not Fox News and Friends here. That's
Are you sure about that, Tom? Are you sure that the only people left for the government are after the mass resignations and people quitting, that it isn't just a bunch of Fox News and Friends?
So it is actually a relatively underdeveloped area of law, right? Like, you can think of some major decisions from the last 10 years, like Hamdi and Hamdan, where you do have some cases that involve where does the Constitution apply? Does it apply in Cuba? Does it apply to non-citizens? Does it apply to non-citizens in Cuba? Which is sort of what that line of cases is about. And it actually is like a relatively underdeveloped area of law, and it sort of seems worth a shot.
I think this is like, it's a derivative. It's not explicitly linked, but I think it's a derivative of, this John Yoo theory of executive power, right? Which is the executive is like almost like a king, And I know this has to deal with the rights of immigrants and but I think there is this idea that the rights are very ill-defined, or very like strictly defined, but the executive branch's power is extremely broad. It's a really weird thing to see a bunch of like federalists and like conservatives taking such a limited view of individual rights and such an expansive view of government rights.
And maybe this is another. It's either maybe a misstep on the government's part, or maybe they're just setting it up for the Supreme Court. Because the reason I say it's one of those two. First, it's a misstep on the government's part because I'm looking back at the opinion and the way the Ninth Circuit dispatches this argument that the individuals have no rights under the Due Process Clause is just citing and quoting a Supreme Court case, which, and here's the quotation, "They apply to all persons within the United States, including aliens, regardless of whether their presence here is lawful, unlawful, temporary, or permanent." So that's a Supreme Court case, and
that seems pretty damn clear.
Yeah, well, the Ninth Circuit is bound by that law, that rule, and so if they're not setting it up for an argument at the Supreme Court that, look, maybe you need to either reconsider what you said in this 2001 Supreme Court case, or that Supreme Court case doesn't apply, or maybe.
But that case was about people in the United States, right? So, like, does the Constitution reach as far as the boarding gate in Beirut?
Well, I think to answer those questions, you'd have to know who the individual is that's boarding that plane, right?
If it's an American citizen, it should, right?
Yeah,
if it's a green card holder, it probably does. But if it's a random person, you know what I mean, that has been approved, well, that's the other thing. If they have been approved by the U.S. government to enter the United States, right, is that something that is revocable without due process?
No. I mean, I don't think so.
It shouldn't.
Yeah, I think, and that's why these government decisions are so important, and you need to put people in charge that really know what they're doing, is because when the government acts towards or an individual, they are, that has implications in terms of what rights that individual gains and what interests that individual gains. And when the government acts towards that individual and gives them a right or an interest, however small it may be a minuscule interest, a 2-week, visa to the United States, that's still an interest that the government is giving an individual. And when you revoke that interest, the government has to go through some extra steps in order to do that.
I found one other wrinkle that I thought was really interesting. One of the state's theories, one of the statutes that the Washington and Minnesota rely on is the U.S. Religious Freedom Restoration Act. And so, for a little bit of background, the Religious Freedom Restoration Act was passed in 1993. It was in response. Correct me if I'm wrong. Wasn't it adopted in response to Smith v. Oregon?
Yeah. Well, so my memory on this is hazy, but this is actually a super interesting area of law because basically, there was a state that passed sort of a generally applicable rule. I think it was it was either the peyote case or the chicken head case.
It had to do with peyote, didn't it? Yeah, it had to do with peyote.
So Employment Division, which in Oregon, so you can call it Oregon.
That's it. That's it.
Was a case where there were some people in Oregon who used peyote as part of their religious practice, and the government of Oregon had some employment policies that said you can't use peyote, and they fired these state employees for having used peyote. And they sued and they said, we use peyote as part of our religious practice. This is burdening our First Amendment right to the free practice of religion. And the Supreme Court said that peyote is sort of an interesting facet of your religion, but it isn't a core religious belief that you have. You could...
What the Supreme Court was doing in that case is saying, look, yes, you have these religious beliefs, but when you have a generally applicable law that's passed, your religious beliefs don't get to trump that generally applicable law unless there are very specific categories of generally applicable laws. For example, you could think of a generally applicable law that is passed to target specifically one group of individuals. So if you were to pass a law that said, for example, that no one could wear a turban, right? Well, there are specific religions where that's part of their religion, and if your purpose was to discriminate against that religion. I forget the exact language the court used, but the idea is if what you're actually trying to do in passing this generally applicable law is to target that religion, well, then that generally applicable law is not going to pass muster. But whereas, as in the case of Oregon, what you're trying to do is pass a generally applicable law that regulates all people from taking certain types of substances versus other types of substances. Well, if you just so happen to have a religion where that's one of your religious tenets, well, you still have to abide by that generally applicable law. And then in response to this Supreme Court case, Congress passed the Religious Freedom Restoration Act, that said, whoa, look, let's turn it about face. If you have a religious belief, then the generally applicable law must pass what's called strict scrutiny. And that's this idea that the court is going to really scrutinize these generally applicable laws to make sure that the state really needs to pass these laws.
So Bernie was the first case the first major case after RFRA was adopted. And in the city of Bernie, there was a city in Texas.
Oh, that was the Catholic diocese, right?
Yeah, there was a city in Texas, and they had some sort of building or zoning regulations, and there was a Catholic church in San Antonio, Texas. The Archbishop of San Antonio wanted to do some renovations in this church in Bernie, and the government said, no, you can't do those renovations because it's an historic building. And it sort of seemed like this innocuous, generally applicable law that applied to all buildings and not just to churches, but nevertheless, the court interpreted the Religious Freedom Restoration Act to say, well, what the Act states is government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. And so...
Wait. AJ, hold on. Let me back up. So my memory of this, and I don't have it in front of me, my memory of this was the Supreme Court struck it down yet again and said, well, no, Congress doesn't get and this goes back to our topic at the beginning of the hour. The court said, look, Congress doesn't get to rewrite the Constitution. The courts are the final arbiters on what the Constitution says and what it means. And so Congress can't pass a new rule trying to override the court when the court is interpreting the Constitution. And so the court struck the law down insofar as it applies to states and private individuals, right? So you can't use RFRA against a state, and you can't use RFRA against a municipality, and you can't use RFRA against a private individual. But the RFRA stays alive insofar as RFRA creates an exception to federal statutes, right? So if there's a general federal law that says you can't build a house greater than, 20 feet high, and you have a religious tenant that says, well, I want a house that's 21 feet high, I'm making these up out of thin air. RFRA then applies to that lawsuit in the sense that you can use RFRA to say, no, that statute doesn't apply to me, see RFRA. That's my understanding. But
the interesting thing about the way RFRA was interpreted in Bernie is that, if it hadn't been struck down as it applies to the states, that the outcome of the case would have been that RFRA really does seem to be prohibiting the state from telling the diocese how to renovate their church. I mean, that's sort of like a fair synopsis if you want to give the whole history of the case, right? And so, but to me, the interesting thing is that, if something like having to hold services in an unrenovated church is a burden on your religion, I mean, sort of imagine any policy that could even be loosely linked to any of President Trump's campaign promises. Like, how could any of them survive RFRA?
Well, and it's important to note, even under all of the Supreme Court law, RFRA would apply to everything that President Trump does, either as an executive order or anything that the Congress passes.
I mean, I think RFRA started with the right intentions, and I think RFRA eventually evolved. And, some might think it's still the right intentions, right, is to be something that conservatives relied on, right, when they felt that the rights of Christians were trampled upon. And so it's good to see the statute, right, being used by people that are Muslim or that are speaking up on behalf of Muslims. So I think this is all like an example of the system working in a way, I'm heartened by it, honestly.
All right, you want to talk about something pleasant?
It's a system working, AJ. Tom, I mean, the audience has already had an hour of our time. How much more are we willing to give them? You know what I mean?
Yeah. Maybe next week?
I think next week we talk about cooking.
I think I'm going to cut all the cooking talk from this episode.
All of it?
All of it.
But don't you want to tease our listeners, to tell them like why they should listen? I don't know.
I don't think they should listen.
Well, AJ, I'll let you cut whatever you want.
Yeah, dude, I trust your judgment. In conclusion,
our democracy is a shambles, and we probably ought not to have a judiciary.
I want to make a different conclusion, which is slightly more nuanced than that. I think our democracy is working decently well for the first time in a long time, and I think our court system is speaking up as well, and I'm pretty excited to see it.
One vote for the judiciary, one vote against. Tom, where are you at?
It's a good question. Can I be on the side of certain judiciary portions we strike down and others we don't?
Just the Republican appointees?
No, there are several good Republican appointees.
I'm impressed with the judges so far, and I'm excited to see if this ends up being like an 8-0 decision at the Supreme Court. I feel like if John Roberts wants to cement his legacy, this is the way to do it. And that will either be that he destroyed the Republic because he got the judiciary into a war with the executive branch that the judiciary did not win, or it will be because he stood up to the executive branch and, like John Marshall before him, got it done.
Well, it's going to have to either be an 8 or 9-0 decision, I think.
A split decision will not work. Like, that will be like a failure. I don't care.
It'll be tough.
Yeah, if there's a split decision here and Roberts can't get an 8-0 or a 9-0, I think this will be whatever the decision is, it will be a failure.
All right, that sounds like 2 votes against the judiciary now.
I'm just telling them how not to be failures. Because I know John Roberts is going to read this or listen to this.